Oh, Ruhama, yes, please do. Uh, I guess I have sent her all the videos that were displayed, including the longer one, the 39-minute video. You mean that one? I have sent her the longer video, a 39-minute video. Yeah, I've sent her already. But I can resend it. I can resend it maybe. I can resend it for you particularly, but I can see that I have sent her. Yeah, I've sent her. Yeah, it's okay. It's okay. So I think we can start the class now. Yeah, so in our last class, we were discussing the charter-based mechanism to protect human rights. As we said, the charter-based mechanism emanates from the United Nations Charter, and the UN organs are the ones which play a huge role in the protection of human rights using various organs within the United Nations. We said that there are six traditional United Nations organs, but these days there are around 8 UN organs which specifically play an immense role in the protection and promotion of human rights. So what are these 8 organs? Can someone remind us what we were discussing on these 8 organs very briefly because we have a very limited amount of time today. So what are the 8 UN organs that we have been discussing in our previous class? Maybe you can also write in the chat box or just unmute yourself and remind us what we were discussing. Yes, yes, Ruhama. For human rights, yeah. Yeah, so Ruhama summarized our discussion very well, except the Human Rights Council. So, one of the organs of the United Nations with a very huge role in the respect and protection of human rights is the Human Rights Council. This council have various procedures, including individual complaint procedures. We have discussed about the 1203 procedure and the 1503 procedure. So the 1235 procedure is a public procedure where individuals and other human rights organizations bring to the attention of the United Nations various human rights violations, gross human rights violations across the world. And also the 1503 procedure, which came later to the 1235 procedure, is a one where human rights violations will be dealt confidentially for the security of individual complainants. So these procedures are procedures within the Human Rights Council, and more importantly, we have discussed the Universal Periodic Review, the UPR procedure, where each and every state of members of the United Nations will be reviewed. This review procedure takes normally 4 years. It happens every 4 years. So within this cycle, all of the 193 members of the United Nations countries will be reviewed. They will be reviewed. Their human rights situation will be analyzed. I wish we could go to a deeper revision on this UPR procedure and the Human Rights Council, but in the interest of time, I'll be sending you various short video clips, interactive video clips, and you would be able to understand for yourself how the Human Rights Council works and how it highly contributes to the protection and promotion of human rights worldwide. So you'll receive these videos after this class. I'll send that to Rihanna, and I'll make sure that you understand very well how the system works. So apart from the Human Rights Council, as Rohama said, we have the General Assembly, the Secretary General Office, the Office of the High Commissioner for Human Rights, the ICJ, the International Court of Justice. So all these organs of the UN play a huge role in protecting and promoting human rights worldwide. So today's discussion will be on the regional systems of protection of human rights. As we said, human rights are universal and they apply to all human beings, but yet regionally there are various procedures and processes depending on each region. There are various human rights systems, regional systems, so it's clear that there are regional variations in the implementation of human rights, even though human rights apply to all mankind universally. So we will see three of the most developed regional human rights systems, which are the European human rights system, the African human rights system, and the Inter-American human rights system. So you could see a stark difference between these human rights systems, maybe in terms of their classification of human rights, in the way they make rights justiciable or not, and in the overall structure of human rights. So there are differences within these regional systems, and we will see these differences. Not only that, we will also see how each human rights system, each regional human rights system functions, and you will be able to distinguish between the European, the American, and the Inter-American system. We have the Asian and the Arab countries' human rights system, but it's not yet developed as such, so we will dwell our discussion just on the three of the human rights systems. So when we see the African human rights system, it operates within an international political organization, which is the African Union. So as you know, African Union is an umbrella organization for all African states, at least for most. So this organization is the main player within the regional African human rights system. The main document which provides for protection of human rights in Africa is the African Charter. the African Charter on Human and People's Rights. This charter was followed by other human rights instruments, including the African Charter on the Rights and Welfare of a Child and the additional protocol to the African Charter on Human and People's Rights. So the regional African human rights system starts from this instruments, from these legal instruments. Besides the legal instruments, there are also institutions which are used to enforce the norms, as we shall see in today's discussion. So what are the distinctive features of the African Charter? What makes it unique? What makes it different from other regional systems? The first distinctive feature of the African human rights system is it provides for the indivisibility of human rights. So we said that the division of human rights into civil and political rights on the one hand and economic, social, and cultural rights on the other hand is something more of ideological. The preamble of the African Charter clearly says that the enjoyment of civil and political rights cannot be dissociated from economic, social, and cultural rights. So it have an equal look into socio-economic rights as well as civil and political rights. So when we look deeper into the contents of the African Charter, civil and political rights are provided from Article 2 up to Article 13. And then we have articles dedicated to socio-economic rights from Article 14 up to Article 70. So this within these articles, the right to property, the right to work, the right to health, the right to education, the right to culture are laid down. And these rights, as you know, are inclined more to economic, social, and cultural rights. So the African culture, the African, Charter specifically and clearly provides that it does not dissociate between rights as other regional human rights systems. Another kind of rights which makes the African Charter distinct is collective rights, which is provided from Article 19 up to Article 24. These articles deal with the right of people which are exercised collectively, such as the right to self-determination, the right to enjoy natural resources, the right to development, peace, the right to healthy environment, and we also have the right to enjoy natural resources. So the African Charter and the African regional system in general is unique because it focuses on collective rights which are to be exercised in group. When we see Article 1 and 27 of the ICCPR, it recognizes the right to self-determination and the right of national minorities to enjoy civil and political rights. These are collective rights, but the African Charter gives more emphasis to collective rights more than other international human rights instruments. It's in a way peculiar because it recognizes many collective rights, such as right to development, right to peace and security, and right to a safe and healthy environment, which have never been recognized by other international documents. As we said now, the ICCPR recognizes the right to self-determination and the right of national minorities, but never does it recognize the right to development, the right to peace and security, or the right to live in a safe and healthy environment. So the African Charter is unique because it recognizes broader rights which are collective in nature. Another thing that makes the African Charter different from other general human rights instruments is the absence of a derogation clause. So Article 4 of the ICCPR allows for state parties to suspend rights. Rights can be suspended during public emergencies. In a similar fashion, Article 15 of the European Human Rights Convention and Article 27 of the American Charter on Human Rights also contain a derogation clause. By derogation clause, I mean a clause which allows states to ban or limit human rights in times of public emergencies. But the African Charter does not have any derogation clause, and states are not in a position to derogate human rights even in public emergencies. So the only thing that the African Charter recognizes is a limitation of rights under Article 27, limitation of rights which are guaranteed by laws. በህግ ላይ ተመስርተው ሀገራት የሂውመን ራይት አፕሊኬሽንን ሊሚት ማድረግ ይችላሉ። ለምሳሌ ፍሪደም ኦፍ ኤክስፕሬሽንን ብንወስድ a person could express his opinions as long as he does not defame an organization or other individuals. ስለዚህ ይሄ በህግ በተቀመጡ ገደቦች ውስጥ መብቶችን ኤክሰርሳይዝ ማድረግ ይቻላል። ዴሮጌሽን ስንል ግን ምንድን ነው? መብቱ በፐብሊክ ኢመርጀንሲዎች ጊዜ ምናልባት የአስቸኳይ ጊዜ አዋጅ በሚታወጅበት ወቅት ሊሆን ይችላል። ሌሎችም ፐብሊክ ኢመርጀንሲዎች ኢንክሉዲንግ ኮሮና፣ ናቹራል ዲዛስተሮች፣ የፐብሊክ ሄልዝ ጉዳዮች ሲኖሩ ግን ሙሉ ለሙሉ መብቱ እስከ መነሳት ድረስ ሊደርስ ይችላል ማለት ነው። ሂውመን ራይቱ ሙሉ ለሙሉ እስከ መነሳት ሊሄድ ይችላል። ይሄ የተለመደ ዓለም አቀፍ አሰራር ነው። ነገር ግን የአፍሪካን ቻርተር ግን does not have this kind of derogation clause. But when we see the jurisprudence of the African Commission on Human and People's Rights, which has a power to interpret the African Charter, this commission also clearly stated that derogation is not allowed within the African Charter. The only thing that the African Charter recognizes is limitation on rights, not derogation. The limitation of rights, as I said, is recognized under Article 27 of the African Charter. So when we look into the case law of the African Commission, in Article 19 versus Eritrea case, there is this organization called Article 19. It is a human rights organization. Maybe you've heard about it. So Article 19, the human rights organization Article 19 brought a case against the state of Eritrea before the African Commission. So the organization was saying that Eritrea violated the African Charter. In that case, one of the defenses that the state of Eritrea raised was, in situations of war, I have a right to suspend some of the rights recognized in the Charter. At that time, Eritrea was with war in Ethiopia, so the country was involved in the Ethio-Eritrean war, and so it tries to justify the suspension of some of the rights because the country is in a situation of public emergency, which is a war. So the African Charter objected this defense by the state of Eritrea, saying that even in situations of state of emergency, a state cannot suspend a right which is recognized in the African Charter. So according to the African Commission, the only ground that justifies the violation of a right within the Charter is limitation, and states are not in place to derogate from human rights. The holding of the Commission is also very consistent, also in other cases that it decided besides Article 19 versus Eritrea case. So the other peculiar feature of the African Charter, besides the fact that it does not allow derogation, is this concept of duty. So usually in international human rights instruments, the focus is towards rights. So human rights are more inclined to rights than imposing duties on individuals. But when we come to the African Charter, it introduces this concept of duty. It's the first international binding human rights instrument which brings forth the concept of duty to the international legal system. So seeing the African Charter from Article 27 onwards, the Charter provides for duties of individuals toward the family, the society, the state, and the international community. So it gives individuals duties towards their family, and then broadly even to the international community. We do not find a similar kind of duty in other general human rights instruments, such as the ICCPR, the European Convention, or the American Convention on Human Rights. They are more concerned on rights than duty, so this makes the African Charter unique. Another thing that you need to take note about the African Charter is that it does not provide for a detailed list of rights. For example, the right to privacy, the right to food, the right to water are not clearly recognized within the African Charter. But then again, the African Commission within its case law have tried to recognize these rights. For instance, if you take the very known case, the Serak versus Nigeria case, the Commission introduced the doctrine of implied rights. So the Commission makes this foundation depending on Article 60. Article 60 of the Charter gives a mandate to the Commission to draw inspiration from international laws, including the Charter of the United Nations, the UDHR, and other human rights instruments adopted by the United Nations. So relying on its mandates to draw inspiration from international treaties and international human rights systems, the Commission adopted this doctrine of implied rights, and it tried to give an interpretation in a way that will include some of the omitted rights, like we said, the right to water, the right to food, are not recognized within the Charter, but through its case law, the Commission, using the doctrine of implied rights, have endeavored to make a way for the missing rights. So in this particular Serak versus Nigeria case I mentioned earlier, the Commission found the state of Nigeria to be in violation of the right to food, despite the fact that the African Charter has no provision which recognizes the right to food. The jurisprudence of the African Commission indicates that even if the African Charter does not recognize the right to food, it is implied from the right to life, which is recognized under Article 4 of the African Charter, and also the right to health, which is recognized under Article 16 of the Charter. So using the rights which are recognized within the Charter, the Commission has worked towards including the omitted rights. So the Commission based its reasoning on Article 4, which is the right to life, that if someone does not eat food, he cannot survive. So the right to life implies the right to food. It also implies the right to water, because if a person does not have food and water, his right to life cannot be ensured. Also, on the basis of the right to health, unless a person have a right to food and water, he cannot be healthy. So using the rights that are guaranteed within the Charter, the Commission tried to include the missing rights through its interpretative exercise. As we discussed earlier today regarding the implementation, earlier in our discussions relating to the international treaties, we said that the International Convention on Economic, Social, and Cultural Rights, under Article 2, it recognizes the obligation of states for the realization of economic, social, and cultural rights. But yet again, this obligation will be based on the resources that a state have. So economic, social, and cultural rights, as we were discussing in our previous sessions, are rights of progressive realization. They cannot be achieved immediately. They are achieved only gradually through time. So state parties, as you know, are not expected to implement socioeconomic rights immediately. This formulation is provided under Article 2 of the ICSR, the International Convention on Economic, Social, and Cultural Rights. Other conventions, other treaties, such as the Child Rights Convention, has also repeatedly recognized what is written in Article 2 of the Socioeconomic Rights Convention. But now, when we look into the African Charter, we don't see any obligation of a progressive realization, unlike the ICSCR or other treaties, which are a verbatim copy of the ICSR when it comes to socioeconomic rights. The African Charter does not, as such, clearly tells us that socioeconomic rights are of progressive realization. So this makes some critics to question whether African countries, which are very poor in resources, can realize socioeconomic rights immediately. If the charter does not, clearly provide for progressive realization, and if this means that socioeconomic rights need to be realized immediately, this would sound, absurd, because given the economic advancement level of African states, it's so bizarre to believe that they can achieve socioeconomic rights immediately. But the African Commission interpreted the Charter in a way to include the obligation of progressive realization of socioeconomic rights. It said that states have the duty of progressive realization of socioeconomic rights. The Commission explained also that states do not have immediate obligations to realize economic, social, and cultural rights. So the Committee on Socioeconomic Rights, the treaty body of the ICSCR, identified two immediate obligations of states. Even though socioeconomic rights are generally of a progressive realization, there are nonetheless two immediate obligations that states need to fulfill with regard to socioeconomic rights. The first one is the obligation of non-discrimination. And second is the obligation to take further steps. So even though states are not required to immediately fulfill socioeconomic rights for their citizens, they have a duty and obligation towards non-discrimination. When they fulfill their rights, let's say gradually or through time, they should not discriminate among peoples in equal standing. Also, even though they are not required to immediately fulfill socioeconomic rights, that does not mean that they should just cross their arms and sit. It means that they need to take further steps into achieving and realizing socioeconomic rights. They should not take regressive measures. They should not take steps backwards. They should work towards taking steps for the progressive realization of socioeconomic rights. So the African Commission, through its interpretative exercise, have read into the African Charter this progressive realization of socioeconomic rights. Even though the African Charter does not provide for the progressive realization of socioeconomic rights, as we have seen the African Commission have included this concept of progressive realization using its mandate to interpret the Charter. Besides what we have seen, the African Commission in its guideline on socioeconomic rights included many immediate obligations on states, besides the fact that socioeconomic rights are of progressive realization. We can see that in its guidelines, the Commission provides for the obligation of states not to take a retrogressive measure, the obligation of states to respect the bare minimum core of socioeconomic rights, and also the obligation of states to take a national plan of action, and this plan of action would help states to take further steps in the realization of socioeconomic rights. So you need to take into account that the African Charter does not make any distinction between civil and political rights and socioeconomic rights regarding the obligation they impose on states. There is no difference, and Article 1 of the Charter also imposes obligation on states to adopt legislative measures under which all states are to be treated in the same manner. And the African Commission has also, in its interpretative exercise, included some of the rights and some of the concepts which were not initially included in the Charter. Some of the rights included are the right to food, the right to water, and also the Commission have introduced this concept of progressive realization into the African Charter. So now, if we see some of the unique features about the African system, let us see how the procedures within the African Commission work. So what are the procedures to bring a complaint before the African Commission? How can countries and individuals and organizations work together with the African Commission? So first, let's see interstate complaint procedure. The African Charter lays down for an interstate complaint procedure under Article 47. But to your surprise, till now there is not much of an interstate complaint that was brought before the African Commission. Interstate complaint, as we discussed on our treaty body sessions, is a procedure where states bring a claim against another state which is violating human rights. So this mechanism is not well used in the international human rights system as well. Also, this is true when we come to the African regional system. We can mention a certain case of an interstate complaint before the African Commission, which is the case between Democratic Republic of Congo and Burundi, Uganda, and Rwanda. So the DRC brought an interstate complaint against 3 states, Burundi, Uganda, and Rwanda. We have this case, but there are no much other cases where countries, African countries, file an interstate complaint on another African state. Second, we have the individual complaint mechanism, which is among the highly sought after complaint mechanism within the African system. The Charter sets out for individual complaint mechanisms under Article 55. Article 55 of the African Charter deals with individual complaint mechanisms. When we see the requirements of admissibility of individual communications, the first requirement of admissibility is standing. The African Commission has adopted relatively, we can say, a liberal approach when it comes to standing. So as you recall from our previous discussions, the treaty bodies, including the Human Rights Committee, will not accept communications from NGOs and class actions unless that these NGOs and organizations can prove their vested interests. So you cannot just bring a case before a treaty body on the basis of actiono popularis or just being concerned about public interest without showing how exactly and individually you are affected by that human rights violation. So vested interests was one of the requirements that we were discussing on the admissibility requirements of the treaty bodies. But this is not the case when you come to the African Commission. The African Commission is very liberal in its standing rules, and it accepts individual cases not only from actual victims, but also from NGOs and from class actions. And these NGOs can bring public interest litigation to the African Commission, even without showing that they are personally affected by the situation. So this makes the African regional human rights system unique from other systems. In other systems, you need to show the consent of the individual. Also, you need to show that you have a vested interest in the case, but in the African Commission procedure, the standing rule is very liberal, and you're not expected to be an actual victim or even from the country where the victim is living. In fact, when we see the statistics, more than 90% of individual communications that were brought before the Commission are from NGOs, not from individuals. We said that in today's discussion, we have seen the CERAC versus Nigeria case. So CERAC is an NGO. It's an NGO working on human rights issues in Nigeria. We have also seen the Article 19 versus Eritrea case. So Article 19 is also a very known international human rights organization. So most of the cases brought before the Commission are by NGOs. Ignorance of the charter and maybe lack of resources are the major reasons why individuals do not bring complaints before the Commission as much as NGOs. The African Commission also gives observer status to NGOs, and it also gives an affiliate status to national human rights institutions. So NGOs can participate in the proceedings of the African Commission. They have an observer status. And even NGOs which are not established in Africa or which have no legal basis in Africa, and persons who are not Africans can also bring complaints before the Commission. So you can see how liberal the standing of the African Commission is. The admissibility procedure is provided under Article 56 of the Charter. Article 56 is a very important article within the African Charter. It provides admissibility requirements in its first paragraph. It states that the author must be known. The author, meaning the one who brings the complaint, should not stay anonymous. The author's name needs to be known by the Commission. The complaint must not be brought based only on facts from news outlets or medias. Also, the complaint should be presented to the African Commission not based on insulting and disparaging words. So it needs to be formal, and there is no need to make the complaint filled with emotive words which insults or disparages the human rights practice of the state, and it should be factual than emotive. Concerning compatibility requirements, all the requirements that we have discussed in the treaty bodies admissibility requirements are also applicable to the African Commission. Paragraph 5 of Article 56 of the Charter clearly requires that domestic remedies must be exhausted before cases are brought to the African Commission. When we see the case law for example, we can mention the Jawara case. In the Jawara versus Gambia case, the African Commission clearly held that domestic remedies must be available, adequate, and effective. So if the domestic remedies are not adequate, or if they are not effective and available, a person can bring his case even though there are domestic remedies remaining. If they're not effective, adequate, and available, it means that they are in effect not available. So a person can bring his case to the African Commission even without exhausting local remedies, exceptionally in such cases. When we see the issue of time, the European Convention requires that a case must be brought within 6 months after domestic remedies are exhausted, but there is no such requirement of time under the African Charter. It only requires that cases should be brought within a reasonable period after exhausting local remedies. It does not provide for a definitive time, as in the case, for example, of the European Convention. The other admissibility requirement of the African Charter relates to duplicating procedures, or the requirement of pendency. Cases which have been examined by another international procedure are not going to be considered by the African Commission. And then besides the Commission, we have the African Court on Human and People's Rights. This is a court composed of 11 judges, and these 11 judges meet together in Arusha, Tanzania, where the head office of the court is located. So they meet only when there are cases, and the African Court Protocol has several differences with the European Court if we compare it side by side. In Europe, every individual of the member states have access to the European Court on Human Rights, but in Africa, only state parties to the African Commission will have access to the African Court. So as it is laid down in Article 5 of the African Court Protocol, only state parties to the African Commission are the ones which will have access to the African Court. Not each and every member state of the African Union will have access to the African Court. Only those who are members of the African Commission will have access to the court. Regarding admissibility procedure, the African Court Protocol also makes reference to Article 56 of the African Charter, so it is more or less similar with that of the African Commission. It have similar admissibility requirements. Only member states of the African Commission and African intergovernmental organizations have access to the court, as I said earlier. Even the African Committee of Experts on the Rights and Welfare of the Child, or other committees established by the African Union, does not have access to the court. This shows that access to the court is in a way limited. However, as an exception, Article 34, paragraph 6 of the African Court Protocol provides that states can make declaration to allow an individual or NGO to submit cases to the court. So even if a state is not member of the African Commission, it can make an explicit declaration under Article 34, paragraph 6 of the African Court Protocol to allow individuals and NGOs to submit cases to the court. Yeah, accordingly, it's only 6 African states, which have made this express declaration to allow individuals to submit their cases. The 6 states are Ghana, Burkina Faso, Mali, Tanzania, Rwanda, and Malawi. So these 6 states, Ghana, Burkina Faso, Malawi, Tanzania, Rwanda, and Malawi, have made this declaration to allow individuals to submit their cases. So individuals and other NGOs in these states can bring their case to the African court since they accepted its competence. And most of the cases which are brought to the African court were rejected on the ground of lack of standing. So whenever a complaint or a case is submitted to the African court, one must give due attention on the grounds of standing, because it may be rejected if a person does not fulfill the admissibility requirements. When we compare the African Commission with the African Court, the African Commission does not have a power to render binding decision. The only power that the Commission has is making recommendations, and recommendations, as you know, have no binding effect. The only way that a recommendation made by the Commission will have a binding effect if it's adopted by the General Assembly of States and Governments of the African Union. So if it's adopted in a General Assembly meeting of the AU, that recommendation will be binding, but in all other cases, it will remain just a recommendation, and it will be up to that state and NGOs and national human rights institutions within that state to enforce the recommendation. It's not binding. But the decisions of the African Court, as I said, are binding. You can see this under Article 13 of the African Court Protocol. Decisions of the court are binding, and in such a way they are more effective than decisions of the Commission. So when bringing cases, one has to look into this competitive advantage of the court than the Commission. The African Union, as you know, have 2 major organs. The Assembly of States, which is the General Assembly, and the Executive Council. There are other organs of the African Union, of the AU, but the 2 major organs are the Assembly and the Executive Council. The Assembly is composed of all member states of the African Union, and the second powerful organ, the Executive Council, is composed of the foreign ministers of African states. If you remember, when the African Union Summit was being held here in Addis Ababa before COVID, before the General Assembly of States meets, first foreign ministers from all over Africa will come to Addis for the meeting of the Executive Council. So the Executive Council is composed of foreign ministers of African states, and they also work on various human rights issues, and they put pressure on states to implement the decisions of the African Court on Human and People's Rights. And also, according to Article 45 of the African Charter, the African Commission is mandated for the promotion and protection of human rights, and as we have seen, It's also mandated to the interpretation of the African Charter. Article 2 of the Protocol to the African Charter also clearly states that the mandate of the African Court is to complement the human rights protective jurisdiction of the African Commission. So these two organs, the African Commission and the African Court, work in collaboration, and they join hands to ensure the promotion and protection of human rights in Africa. So if we have said this about the African regional system, let's proceed to our discussion on the second major regional human rights system, which is the European human rights system. I hope the discussion on the African human rights system is clear. So with that, we can proceed to our discussion on the European human rights system. So the European human rights system works within the Council of Europe. The Council of Europe consists of 47 member states, and the major instrument of human rights in Europe is the European Convention on Fundamental Rights and Freedoms. So the Council of Europe is totally different from European Union. The European Union, the EU, has its own instrument called the European Charter on Fundamental Rights and Freedoms. This Charter on Fundamental Rights and Freedoms is implemented by the European Court of Justice. So in the same way that the ICJ, the International Court of Justice, implements the United Nations Charter, the European Court of Justice is also established to implement the European Charter on Fundamental Rights and Freedoms. So this court is found in Belgium, Brussels. Its headquarters is in Brussels. The European Union was established in 1949, and 1 year later, the EU adopted the European Convention on Human Rights. The EU have 27 member states. The European Convention on Human Rights as well have 27 member states. But here, the main point that you should note is the major human rights system in Europe is not within the European Union. It's not a system which is based mostly on European Union. Rather, it's under the Council of Europe. So the Council of Europe is the one which establishes much of the human rights system in Europe than the European Union. ቅድም እንዳየነው አፍሪካ ላይ ግን ሂውመን ራይትስ ሲስተሙ ኢማኔት የሚያደርገው ከአፍሪካን ዩኒየን ነው። ዩሮፒያን ሪጅናል ሌጋል ሲስተም ላይ ግን ሂውመን ራይትስ ሲስተማቸው ከኢዩ ከዩሮፒያን ዩኒየን ሳይሆን የበለጠ ካውንስል ኦፍ ዩሮፕ ከሚባለው ሌላ የኢዩ ሁለተኛ ከኢዩ ፓራራል ባለ ሁለተኛ ኦርጋን ስር ነው አብዛኛው ሂውመን ራይትስ ሲስተማቸው ያለው ማለት ነው። This Council of Europe is a supervisory mechanism, and it established the European Court of Human Rights, and the European Court of Human Rights is found in Brussels ማለት ነው። The European Court of Human Rights directly works on the European Convention on Human Rights, and this convention deals with civil and political rights. It does not contain socio-economic rights. It has 14 additional protocols, and these 14 additional protocols made several procedural as well as substantive amendments to the European Convention on Human Rights. These additional protocols include many various human rights issues. For example, in 1919, we can see that one of the protocols amended the European Human Rights Convention by adding the right to education. So European Human Rights Convention, unlike the African Human and People's Rights Charter, does not include socio-economic rights. It's only have civil and political rights. It's only later on that socio-economic rights were included within the European system. Apart from the European Convention on Human Rights, there are also other conventions in Europe. One of these conventions is the 1987 European Convention on Prevention of Torture and Cruel and Inhuman Degrading Treatment Convention. This convention have an implementing body, which is the Committee on the Prevention of Torture. This committee examines European countries regarding torture, and it makes various reports regarding torture, but it does not make any binding decision, unlike the European Court on Human Rights. Finally, the European system come to adopt a social charter, which is the European Social Charter, which was adopted in 1961. This social charter deals with economic, social, and cultural rights. The implementing organ of the charter is the European Committee on Social Rights. This committee does not have a power to oversee individual cases. Only collective complaints are submitted to the committee. It also makes reports, but it does not give binding decisions like the European Court on Human Rights. The third human rights framework of the European regional system is the Convention on National Minorities. It was adopted in 1994, and it has its own implementing organ, which is called the European Committee on National Minorities. Apart from these organs, there are also other political organs within the Council of Europe, which are concerned on human rights. One of them is the Committee of Ministers. The Committee of Ministers will oversee the implementation of decisions of the European Court on Human Rights. There is also another political organ called the Commissioner on Human Rights, which helps to improve the activities for the promotion of human rights within Europe. So let's have a zoomed focus into the European Court of Human Rights. The court functions within the Council of Europe. In Africa, the African Court consists of 11 judges, but that is not the case in European Court of Human Rights. The plenary court will have 47 judges, and one state party will send one judge to the European Court. So the court is representative of all the states within Europe. Each country will have the opportunity to send one judge to the court, and there will be total of 47 judges sitting in the bench, unlike the African court, which only consists 11 judges. When we see how the court entertains cases, it have one judge rapporteur. The judge rapporteur is a single judge who will deal with the admissibility of cases. If the case is found inadmissible, that single judge will automatically reject the case, and the decision will be final. But if the judge considers that the case contains some complicated issues, he or she will send it to the committee of judges. This committee is composed of 3 judges. If the case is simple, the committee will decide and consider the case both on admissibility and its merits. However, if the committee thinks that the case is more complicated, it will send the case to the chamber of judges, which consists of 7 judges. ስለዚህ በደረጃ በየደረጃው ነው የሚሄደው ማለት ነው። So if that single judge መጀመሪያ ላይ ያልነው rapporteur judge ያያል if he thinks it's complex ለኮሚቴ ኦፍ ጀጅስ ይመራዋል ሶስት ጀጆች ያሉበት ማለት ነው and then again if this committee thinks that the case is even more complicated it will send it to the chamber of judges which includes 7 judges but again if a state party or an individual considered that his case has not been examined properly and appropriately, he may go to the Grand Chamber. So the Grand Chamber unit of the European Court consists of 17 judges. But before the case is taken to the Grand Chamber, final of 5 judges will decide whether the case will go to the Grand Chamber or not. For instance, if the issue in the case is very serious and if there is a fundamental error which will likely change the decision of the previous chamber, the final 5 judges may permit the party to take the case to the Grand Chapter, to the Grand Chamber. This is all about how procedurally the European Court on Human Rights functions, but presently the court is facing some serious challenges. The first challenge is there is a docket crisis, there is a backlog of cases, there are around 1,000 cases brought before the European Court of Human Rights each year. So this gives a hard time to the judges and there is a backlog of cases. Another challenge is the issue of legitimacy, particularly UK, United Kingdom severely criticizes the power of the court. In UK, as you know, the parliament is the highest body. There is a parliamentary supremacy. The laws that are enacted by the parliament of the UK were being rejected by the European Court of Human Rights as violating human rights. That is why that countries such as UK, Belgium, Netherlands are criticizing the functions of the court. They say that the court lacks legitimacy to nullify laws which are passed by state parliaments, since the parliament is elected by popular vote and it is a legitimate organ to enact laws. For example, if we see a certain case, a law which was passed by the UK Parliament, which prevents prisoners from voting, was nullified by the European Court. The European Court on Human Rights made a decision against this law of UK, which bars prisoners from voting, saying prisoners can't vote since they have a right to vote which is guaranteed in the European Convention on Human Rights. So at times the decisions of the court would go as far as nullifying laws which are issued by state party parliaments. So this in a way makes its legitimacy into question, and most UK medias in a way are into the business of criticizing the European Court on Human Rights, but we can say it is still making a huge contribution to the advancement of human rights in Europe nonetheless. I am hoping that the European human rights regional system is clear for you guys. And finally, let us see the third regional human rights system, which is the Inter-American human rights system. The Inter-American human rights system ስንል ብዙ ሀገራቶችን የሚያጠቃልል ነው። ኢንተር አሜሪካን ስንል በሳውዝ አሜሪካ ያሉ ሀገራቶችን በሙሉ የሚያጠቃልል ነው ማለት ነው። So when we say the Inter-American system, don't just think about the United States. It's a human rights system based on the broader countries located within the South American region. So the Inter-American Human Rights System operates within the Organization of American States. The charter which establishes the Organization of American States was adopted in 1948, as it is provided under Article 3 of the Charter of the Organization of American States. The main purpose of this organization is working on the recognition, promotion, and protection of human rights without any discrimination on the basis of sex, color, race, religion, or any other ground. This indicates that it reflected the objective of the United Nations Charter, which, as you all know, is adopted in 1945. So the Charter of the Organization of American States also establishes certain organs such as the General Assembly, the Secretariat, the Judicial Committee, and Council of Ministers. In the same way as the African Union, the American states also have an organization, which is the Organization of the American States ማለት ነው. Following the charter, which is the Charter of Human Rights ማለት ነው, የኦርጋናይዜሽን ኦፍ አሜሪካን ስቴትስ Human Rights Charter. Following that charter, the American Declaration on Rights and Duties of Man was adopted. It has no binding effect on states. In 1959, however, the Council of Ministers of the Organization of American States established the Inter-American Commission on Human Rights by resolution. This Inter-American Commission is something which you can see parallelly with the African Commission on Human and People's Rights. The mandate of the Commission is to report and to follow up on the implementation of the American Declaration on Human Rights. This is the general framework of the American human rights system, but the main treaty in American legal system, in the Inter-American legal system, is the American Convention on Human Rights, which was adopted in 1969. This convention has two substantive parts. The first part of the convention deals with civil and political rights. It also makes reference to economic, social, and cultural rights. The second part of the convention provides the supervisory mechanisms. It establishes a new institution called the American Court of Human Rights. This convention also recognizes the mandates of the American Commission on Human Rights. In Africa, it is the African Charter itself that establishes the African Commission, but in America, the American Commission was established even before the adoption of the American Convention on Human Rights. As we said earlier, the Commission was established by ministers, by foreign ministers of the Organization of American States. So it's not as such established by the convention itself, as in the case of the አፍሪካን ቻርተር ላይ አፍሪካን ኮሚሽን የተቋቋመው በቻርተሩ መሰረት ነው። ኢንተር አሜሪካን ሪጅናል ሲስተም ላይ ግን የኦርጋናይዜሽን ኦፍ አሜሪካን ስቴትስ ካውንስል ኦፍ ሚኒስተርስ ናቸው ኢንተር አሜሪካን ኮሚሽን ኦን ሂውማን ራይትስን ያቋቋሙት ማለት ነው። So the convention, the American Human Rights Convention, only makes recognition to the mandates of the Commission. It has not established it, but the Convention gives recognition to the mandates of the Commission. The American Convention on Human Rights was also supplemented by other human rights instruments which came later in date. One of them is the 1985 American Convention on Torture, which was adopted to prevent and punish torture. The convention has two additional protocols. The first protocol is the protocol called San Salvador. It specifically provides for economic, social, and cultural rights. Economic, social, and cultural rights are not provided in the American Convention, but they are added using this San Salvador additional protocol, which specifically deals with socioeconomic rights. This is similar with the additional protocol of the African Charter, which added women's right to the Charter. As you know, the Maputo Protocol, the Women's Protocol, is an additional protocol to the African Charter, and it further adds to women's rights. So in this same manner, the San Salvador Protocol adds socioeconomic rights to the American Convention. Also, there are a few protocols in specific socioeconomic rights, such as the right to education. Also, in the European system, as we were discussing, there is the European Social Charter, but it has a totally different mechanism in the area of socioeconomic rights. In Africa, as we discussed in our earlier discussion today, there is no distinction between socioeconomic rights and civil and political rights, because the African Charter holds both together in a single document. The second protocol to the American Convention on Human Rights, next to the San Salvador Socioeconomic Rights Protocol, is the 1919 Protocol on the abolition of death penalty. In 1994, the Organization of American States adopted two other conventions. The first one is the American Convention on Prevention and Punishment of the Violence Against Women. But when we see the development at the UN, it does not focus in the area of punishing violence against women. The aim of the Convention on Elimination of Discrimination Against Women, the aim of the CEDAW ማለት ነው, is only elimination of discrimination against women. The CEDAW committee only discusses violence against women as one ground of discrimination. It does not go any step on the issue of punishing violence against women. So this is a new foundation dealt within the American Convention on the prevention, not only prevention, but punishment and eradication of violence against women ማለት ነው። ስለዚህ CEDAW only deals with elimination of discrimination, but the convention, the sub-convention, which is a protocol to the American Convention, specifically deals with the punishment of violence against women. Another convention adopted in 1994 within the Inter-American Regional System was the Convention on Forced Disappearance of Persons. So the Inter-American System have its own convention on forced disappearance of persons. This makes it a leading regional system in the world regarding the normative development in the area of forced disappearance. Unlike the Inter-American System, the UN Convention, the UN Convention on Forced Disappearance is a very recent phenomenon which entered into force only in 2008, but the Inter-American Regional System has its own convention on forced disappearance since 1994. The United Nations system is 7 years back from the American Convention in terms of the normative framework of forced disappearance. This makes the Inter-American human rights system leading in the area of forced disappearance. የተለያዩ አምባገነን ሪጂሞች ነበሩ ላቲን አሜሪካ ውስጥ፣ ይሄ ቺሊ፣ ኮሎምቢያ ምናምን እና this dictatorship regimes were highly into the human rights violation of forced disappearance. So we could attribute the leading role of the inter-American human rights system on the area of forced disappearance to these human rights situations in Latin America. Another area that the inter-American human rights system contributed to the world is the Convention on Elimination of Discrimination against persons with disability, the Disability Convention ማለት ነው. So the inter-American regional system has its own Convention on the Rights of Persons with Disability since 1999. And we can see that the UN have taken experience from the inter-American system while it adopted its treaty on persons with disability. So የpersons with disability treaty የሚወጣው በ2006 ነበረ. So ኢንተር-አሜሪካን ሲስተም ግን ገና በ1999 የራሱ የሆነ persons with disability convention ነበረው. So the UN also have taken experience from this system ማለት ነው. In terms of its institutions, the Inter-American Commission on Human Rights was established by the resolution from the Council of Ministers of the Organization of American States, and the commission consists of 7 commissioners. While the African Commission has 11 commissioners. When we compare the American Commission with the African Commission, the American Commission carries out its functions in lesser budgets than the African Commission, but astonishingly, it's more efficient than the African Commission. The main mandate of the Commission was conducting reports on the implementation of human rights, on the basis of the American Declaration of Rights and Duties of Man. This commission makes reports to the Organization of the American States, and this Organization of American States will put political pressure on states to implement their convention obligations. When the American Convention on Human Rights entered into force in 1979, the Commission began receiving individual complaints. This means it is the American Convention on Human Rights which gives the mandate of receiving individual complaints to the Commission. So the Commission will receive individual complaints, and regarding the procedures, it's almost identical with that of the African Commission on Human and People's Rights, except that the American Commission have only 7 commissioners, while the African Commission have 11 commissioners. With regard to standing, the American Commission also follows a very liberal approach. There is a liberal approach to standing, and individuals, group of persons, and NGOs can bring cases. This is similar with that of the African Commission. So it's possible to say that the African Commission lended its procedures from the American one. And when the standing requirement of the American Commission is not enough, it may also look into the treaty bodies and the jurisprudence in the treaty bodies. So those all admissibility requirements we have been discussing while looking into the treaty-based mechanism also works in the regional systems, and the American regional system is no exception ማለት ነው. So I am seeing that we are running a bit out of time, but we have about 5 minutes. So if it's that okay, we can finalize our discussion on the American Commission, and then we will summarize this discussion in our next class. Summarizing our discussion on the American Commission, we can say that out of the 35 states within the South America and North America region, 23 states are parties to the American Convention on Human Rights. If a complaint is presented before the Commission against a state which is not party to the Commission, it can put a political pressure on a certain state to engage in a process. For example, in 1962, the Republic of Cuba was suspended from the Organization of American States because of the pressure of the American Commission on Human Rights. Also, the Commission may send cases to the Inter-American Court on Human Rights if a state is not party to the court. For example, the US is still not a party to the American Convention on Human Rights and even the American Court on Human Rights, but cases are brought to the American Commission against USA. So the Inter-American Commission handles cases against USA on the basis of the American Declaration of Duties and of Rights and Duties of Man. So even if a country is not a party to it, it can extend its pressure, and the country cases can be seen against that country even if it's not a party to the Convention on Human Rights. These are some of the things that we need to know about the Inter-American human rights system. We will finalize this discussion on regional systems in our next class. So maybe we can end today's class here. I have heard that you have a class at 3. So I think it's good if we end this class here, and as promised, I'll send you a summarizing videos on the UN Charter. I'll send it to Rihanna and she'll share it. So have a good day and goodbye.
Edit.